I'm making these videos and these podcasts because I want to get the knowledge, the strategy out there so people that are going through probate or looking to go through probate or that could skip it, avoid it. Hopefully, these podcasts, these videos I make will help you. Today, we're going to interview April Thrasher. She's an escrow officer with Grice Title and Law in Colleyville, Texas. She's amazing. We've done several transactions with her on the buy side of stuff where we made cash offers and we've closed with them, and as a real estate broker where we helped our clients sell property. So anything you need, if you're looking at this and watching this video prior to filing probate, this is the perfect video for you to watch Affidavit Heirship so you can avoid probate, the cost of it, or simply understand it better. So enjoy the video. I look for you to give us a call if you need help.
I'm here with April Thrasher, an awesome lady.
Thank you, David. Thank you for having me. I'm April Thrasher with Grice Law and Title Firm. We are a full practicing law firm and title company. However, I am not an attorney. I am just an escrow officer speaking from 20 plus years of experience and curative title issues, specifically in probate and affidavits of heirship. So that's the perspective I'm speaking from today, even though I'm going to reference the probate code several times, just because that's part of what our title requirements are.
Yeah.
So yes, it is a very common way to break a gap in the chain of title when someone passes. It's wise, even if you're going to hold the asset, it's wise to go ahead and cure that break in the chain of title because it's better to do it soon rather than later. The risk of doing it later is more descendants or heirs in the chain of title pass away, and then that's more heirship affidavits or probates you have to address. So let's get into what that means a little bit. Let's give an example. There are husband and wife. And by the way, I'm speaking strictly from a community property perspective. Separate property, meaning investment property, anything outside of your community property assets. Maybe you had a prenup, maybe you had a postnup. Anything that identifies the real estate as separate property is going to be a separate conversation. The probate code addresses that completely differently. But we are going to speak from a community property perspective, meaning husband and wife occupied the property, lived there as their homestead. That is what identifies that as community property. So let's just say husband and wife own a house. Let's just for conversation purposes say grandparents own a house. Grandmother passes, grandfather survives. There's going to be a conversation is there a will? That's important. It's going to be important whether you do an affidavit of heirship or you decide to go probate. Is there a will? What were the wishes of that will? We're going to identify those two things first. Let's say the family doesn't want to go through the probate process. Maybe there weren't a lot of assets. Maybe there's not a large sum of money sitting in a bank account somewhere. Maybe there aren't 5 cars that we have to retitle. Maybe they just had a house, maybe a couple of houses that we need to liquidate those assets to either pay off expenses, maybe support grandpa while he's still living, and maybe he has to go into an assisted living facility. There is an easier way to do it and cheaper than going the probate route, and that is an affidavit of heirship. What's going to be required to do an affidavit of heirship? Well, first, your title company or your law firm, whoever services you engage, are going to send you an affidavit of heirship questionnaire. And that's going to be completed by a direct heir of the decedent. The decedent will be the person that passed. So in this case, it would be grandma's mom would be the decedent. Next of kin, whether it be grandpa, will be the affiant on the affidavit of heirship, or maybe one of the children. One of the children, they'll complete the questionnaire. It's going to be completed with questions like marital history. Was there only ever one marriage? If not, what were the other marriages? How did they end? Did they end in death or divorce? We need to identify those facts. Then we're going to ask who were the children of the decedent. And this is an important time to say this happens often. Just because a child may have passed at birth, just because a child may have passed without being married, maybe they were younger, they still have to be named and included.
Wow.
If sibling disowned the family at the age of 18 and they haven't had anything to do with anybody in 25 plus years, they have to be included. Most title companies and law firms are going to fact check what you put on the heirship affidavit. We have resources to be able to do that. At the very least, we're going to look at public record like obituaries, funeral announcements, things like that. That brings me to a number 2 big problem we have. When you're writing your funeral, your obituary, or whatever you're going to read at the funeral, a lot of people, maybe there was a niece or a cousin or somebody that got raised in your household that you called your brother your whole life, but was not your biological brother.
Yeah.
Please do not put that that was your brother anywhere. We were just talking about completing the questionnaire for the heirship affidavit. It's going to be very specific in the questions it's going to ask. It's going to ask for marital history. If there was more than one marriage, how did the prior marriages end? Was it death or divorce? Were there children born out of that marriage, prior marriage, that is? And what children were born out of the marriage. Maybe grandpa was already divorced from grandma and the divorce decree would have addressed who took ownership of the real estate. Now we just have to decide who grandpa's heirs are. So the way we determine heirship is first we go to spouse and then to children. If there are no children, let's just say there are children, but the children are deceased. Now we have to determine heirship for the children. So now we're looking at grandchildren. If we can't go down, then we're going out. So if we can't find any children or grandchildren, we're then going out to siblings or up to parents. So a lot of times, if we're dealing with the elderly community and the lineage is going to stop. I've had a circumstance where the youngest heir was 92 years old.
The youngest is 92.
The
Wow.
youngest heir was 92 years old, and then it stopped. It didn't go anywhere else from there. So, we have to go down, out, and then up if we can't go down any further to determine heirship. Okay. So once you complete the questionnaire, a big part of the questionnaire that people struggle with are disinterested parties. The probate code says if you're going to do an affidavit of heirship, you have to have two disinterested parties that are going to swear to the facts that you've submitted in the affidavit. That means if it's grandpa, you have to find two people. We prefer non-relation, but if we can't, like a neighbor, maybe a longtime family friend, if we can't get a neighbor or a longtime family friend, and we can determine that maybe there's a cousin that isn't going to directly benefit from the liquidation of the asset, the sale of the real estate, we can oftentimes get underwriters to accept a cousin signing as a disinterested party. But the
Okay.
preference is always going to be of non-relation. But here's the kicker. They have to have known the decedent for at least 10 years or more while the decedent was living. So if you're talking about, for example, the elderly community, you
92.
can't have your 22-year-old girlfriend you grew up with your whole life sign attesting to those facts because there's no way they would have known your grandpa for 10 years or more while he was living.
Mhm.
So that's why I say it's always better to address it sooner rather than later. Don't wait because these dates start adding up. You start being able to find less and less people. Maybe when grandpa was the patriarch of the family and he passes, family splits up. They're not getting together anymore. So while it's fresh and everybody has been united in whatever happened, it's best to go ahead and address these issues. I always say, ask the questions before death. Like, let's start talking about, hey, grandpa, do you have a will? That I know people are sensitive to that, but it's better to address it before and figure out what you have to do and what's needed. My parents have both passed. Neither one of them, this is what I do for a living, and neither one of them had a will. My
Mm.
mom was unexpected and it was a mess. I had to clean up a mess. So, same with my dad. I didn't learn that lesson hard enough, I guess, through my mom and my dad passed. It was a mess. So, I tell people address this before as much as you can so that you ask the questions. Call me, call David, ask the questions so it's addressed beforehand. So, you're not scrambling trying to come up with information that's being asked of you after the fact.
Let me ask you a question real quick. What's the understanding of the 10 years? What is that? Why does it have to be 10 years of knowing somebody?
It's because whoever the disinterested party is that's going to swear to the facts that the affiant has listed has to have been familiar enough with the decedent to be able to swear to those facts. So if I've known you for a year, I don't know you well enough to know your lineage or the decedent's lineage. So you have to, they've kind of set the bar at 10 years because really that's long enough to have gotten to know someone well enough that their past, their history.
Okay. I thought it was longer for some reason. I've been telling people 15 years. Did it change?
Preferred.
Okay.
That's a good question, David, because every title company is going to be different in their requirement. So I see here, there is a statement out there that the decedent has to have been deceased for 6 months or more. We don't have that requirement.
Okay.
It can happen before that 6-month threshold. 10 years, our underwriters are comfortable with that. If you're closing with a different title company that maybe is a little more conservative in their risk analysis, their requirements may be different. So if you want to be on the safe side, 15 plus years, even 20 plus years, if you want to be on the safe side, you might have to wait 6 months. But not every title company and every underwriter is the same in that requirement.
Okay. And how long do you have to, the actual document has to be filed with the county records, right? When you're complete?
So once you complete the questionnaire, we were just talking about that, you'll return that to whoever's preparing the affidavit. And please let me, I can't stress this enough. Please don't try to prepare these affidavits yourself
Yeah.
because there will guaranteed be information left out of it. You're going to file it in the public record. It's going to muddy title. And then whenever you go to liquidate the asset or sell the house, we're going to have to fix it. So I know, I mean, talking about spending a couple, maybe $200 or $300 to get an affidavit of heirship done.
Yeah.
It's worth to make sure it's done correctly. So once you present the questionnaire completed back to me with the death certificate, we're going to prepare the actual affidavit that's going to be signed by the affiant. So remember, the affiant is the direct descendant of the decedent. So either spouse or child can be the affiant. They're going to complete it. The two disinterested parties are going to sign it, and then we're going to file it in the public record in the county of where the property resides. For conversation purposes, Tarrant County, Texas. Once everybody has signed it, we will take it and file it in the public record in Tarrant County.
Because I close at several different title companies and I work with several attorneys, and the form is always different. So even the affidavits are slightly different. I've had people go online and get an affidavit of heirship and do one automatically, and then they try to just have that piece of paper and file it for, I don't know, what, $100 or something. And the cost is not in relative of selling a $150,000 property or more or less, to spend $150 or
Even five,
$500. Yeah, it's so worth it not to have that cloud of the title when a realtor goes to sell a property, especially if we have offers on a property, somebody has escrow money, inspections, and they're getting financing for a property. You want to make sure that when we hand it over to you, you have your affidavit and we have everything we need to properly close it.
it's important to say too, if you're selling a property and we have to do this to clean up the chain of title in the process of your resale, you don't pay these fees until closing. This isn't like you have to write a check or pay the you pay that out of your proceeds at closing, and you're going to have it insured. If you're selling a property, your buyer is going to want title insurance. In order for a title company to be able to insure that transaction, this is going to have to be done anyway, and it's going to have to be done properly.
I used to
And
think, I hate to say this, but when I was a young agent, I was like, can we avoid the title company and all that crap? I was like, how do we avoid this?
nobody knows the value until they need it.
That's true. That's true.
Yeah. And then when you need it, you're like, man, that was a small price to pay to protect my biggest investment. Right.
That's right. That's right.
So let's talk about real quick heirship affidavit and how that
Yeah.
property too. So
Okay.
let's just say, we talked earlier that grandma and grandpa were still married. Grandma passed, grandpa survived grandma. But they were both married previously and both had children outside of their marriage to one another. So and let me say, this is where it gets tricky. This all post dates September 1st, 1993. September 1st, 1993, the probate code changed. So if it was after September 1st, 1993, the rule is surviving grandpa would keep 50% interest. Children will get 50% interest. All
Okay.
children.
All collectively.
For 1993, the rule is still the same. 50% goes to grandpa, 50% goes to children. The only difference in the probate code change after September 1st, 1993 is if grandpa and grandma were only ever married to each other and only ever had children together, not outside of their marriage, then grandpa gets it all. Because the state assumes that if you are only ever married to each other and only ever had children together, that it's your intent to take care of your children just as it would have been your spouse's. But after 1993, same. Grandma passes, grandpa gets 50%, children get 50%. Does that make sense?
It does.
So when can you not use an heirship affidavit? This is important. A lot of people say you can't use an heirship affidavit until 6 months have passed since the decedent died. That's correct. That's not a requirement for us anyway. We've been able to do an affidavit of heirship as soon as the death certificate is issued. But yes, we have to have a death certificate issued. Let's just say I get this all the time. Well, I haven't spoken to my brother in 18 years. We don't even know where he's at. We can't find him. We have to find him. So we will exhaust all of our efforts to find one of the heirs. But, we can't just exclude somebody because you can't find them.
Right.
All heirs have to be listed, or all heirs have to be in agreement. I mean, David, you and I have seen many times people
Yeah.
aren't in agreement. I'm pretty successful at mediating, like, let's come to a common ground. But I have had deals where if your family members can't agree on what to do, then we're going to require a court order because everybody has to be in agreement, or a judge can give us a court order determining what we do, which is going to be expensive and timely.
It goes back to we're trying to avoid, most people, they just want to get the property in their name most times, or they're trying to avoid the probate process, which could be 4 months.
It could be time consuming and cost.
Yeah. Why even go that direction? And then some of these properties I'd say most of them are paid off if they're 90 years old. But if there's a mortgage, you got mortgage costs, you got
gotta pay it.
insurance, you got,
Property taxes.
yeah. So
Yeah, that's a lot of expenses. Top of that, if you're covering any kind of funeral expenses, I know when my parents passed, you're writing a check for funeral expenses, things start to add up. So it's important that you understand how those assets, people need to agree.
yeah,
And
especially if they have no skin in the game, really, they not made the payments on the property.
or they're not writing a check for property taxes. Yes.
Yeah, yeah.
Yeah.
I just talked to a guy yesterday. The only reason he's selling his dad's house is because he's backed up $5,700 in taxes on a house that's paid off, and now he doesn't work. He's on disability. The chances of him finding a reasonable rent right now in this economy,
Yeah.
it's like we need to figure out. There's another family member holding it up, so he's like he's forced. He doesn't want to pay the taxes because the other family member that's not living there doesn't want to pay any of the taxes or any of the cost.
But he's
They want to
holding
put
it
it all on. Yeah. So those situations.
Those situations happen. And this is what I always tell people, money talks. So those taxes are $5,700. Offer your heir an extra $2,500 to sign off. And then you're keeping your extra $2,600 or $2,700 that you're not having to pay in property taxes. That's how we mediate it. Money talks when you're coming to heirs. And it just it happens all the time. It changes people when someone passes and there's money on the table.
Right. Yep.
So, but that is going to be a requirement. The heirs have to work it out. Your title company is not going to tell you what you're legally entitled to because we're not authorized to do so. It's going to take I can tell you 50% goes to dad, 50% goes to you and your siblings. But if there are 6 siblings, 8 siblings, or 2 siblings, I cannot legally tell you you're entitled to, a fifth. You guys have to agree. The heirs have to agree. If that makes sense. So once it's filed, that really serves as a deed, putting title into whoever the heirs are. This is what it gets tricky, and this is what I can't impart on people enough. Let's say we have 7 siblings, and title's going to be in all 7 siblings' name and dad's name by virtue of a filed heirship affidavit. Everybody's personal debt is going to now attach to that. So if you have a federal tax lien, if you have a child support lien, if you have a judgment, if you have any lawsuit, open litigation, anything that attaches to your name personally, once you take title by virtue of an heirship affidavit, now attaches to the house you're trying to sell. And it happens often. So before anything's filed in the public record, open up dialogue on that. Somebody has personal debt, start asking your siblings, is there something that you have that we don't know about that we need to start maybe asking some questions? Maybe we need to disclaim interest. Maybe we need to call the debt holder and start trying to work out an agreement. It's important to be upfront about that with whoever's assisting you in this process, because that personal debt attaches. This is not your homestead, so you have no protection under the homestead laws. So it's attached and it's going to have to be paid, which is
yeah. So in this scenario, I'm about to talk to a lady that has 14 siblings. That
better have some conversations.
If one of them has a IRS debt or lien, that could be attached to the property and wipe out all the money, probably. Wow.
Then you would go to the IRS and say, well, they're only in inheritance, so they're only entitled to whatever percentage, and the IRS can do maybe a partial release as long as they surrender what their inheritance would have been. But that's why you have those conversations ahead of time, so we're not holding up a closing because nobody said that until we filed it.
Interesting. Wow.
Good title company or a law firm is going to do a name search once the questionnaire is completed. We're immediately going to order a name search to see what personal debt's going to pull.
Okay. And how long is that let's say one of those family members have an IRS lien of 30 grand. You do get a partial release, but how much delay is that on top of all the other delay of paperwork?
Have you ever called the IRS, David?
No, that's all I'm asking. So,
It's considerable. There's
so
forms you have to fill out to even let us talk to them, and then there's forms you have to fill out to prove what you're saying. It's lengthy. You might as well go through the probate process at that point.
okay, interesting. Let's see. You seem to have this. I had a bunch of questions, but you're answering all of them, so that's cool.
Yeah, I've done this quite a bit, and I've gone through. I mean, I'm pretty much, the key points are. I think it's important to say this too, and I don't know if I've already covered this, but affidavits of heirship really can only be used in real estate. If you have safety deposit boxes, bank accounts that you want to access, savings accounts, you can try to present an affidavit of heirship, but oftentimes they're going to want something certified by the court. So really, this is really only used in real estate transactions to divest interest.
How does this go with the?
Immuniment. Immuniment of title. Immuniment of title is issued by the court, and they're fairly quicker and easier to get than a probate, and it's less expensive. But immuniment of title is just basically going to be a court's determination of the heirship. They'll file the immuniment, and that will transfer title into the heir's name.
Okay.
Or to the beneficiary or whoever the recipient was in the will.
Okay. Yeah, I actually find a lot of people that do 2 closings with you this year that I sent letters to small estate affidavit people that they didn't mention the house, but they were trying to settle a title on a vehicle. But then later on, a year after probate, they wanted to sell a property that they didn't include for some reason. So they had to go through. They
get immunity.
Yeah, instead of doing the affidavits actually filed for. That's another video, but yeah, just another process.
Yeah, we can certainly do another video title specifically, but I do find affidavits of heirship very, very helpful, much less expensive. And because oftentimes when someone passes, you need to liquidate, that real estate pretty quick if there were already arrangements made for those services, the debts, the bills, the property taxes. Those bills are going to keep coming in quickly. So if nobody's prepared to pay those, then this is an alternative to a probate process that will let you get out of that quicker and get out of that financial obligation more quickly.
Okay. What if somebody has a probate filed and they find that that's probably not the direction they need to go in, but they've already spent money on an attorney, but the only thing is the house? What's that process? Do you cancel the probate at that point?
No, you can keep going through the probate and do the heirship affidavit to liquidate the real estate.
There was one that we closed in Dallas that it was over 20 years. The guy was in prison the whole time, the son, and when he got out of jail, he decided to sell the property that his dad left him. So the will was really outdated. We had to do an affidavit. Then we found another brother that didn't want anything at the time of doing a contract, but then at the end, he had to do so much work to find another sibling that they end up splitting the proceeds because it was a mess.
It's a mess. That's a good point too. Probate, depending on if you do an administration, and this is, I'm sure you've had a lot of probate attorneys do this, but if letters of testamentary are issued, those expire. So if the house isn't sold within a certain amount of time, you have to go back to the court and get new letters issued. So, there are all kinds of reasons. So educating yourself, especially if you're responsible for taking care of family members, is super important, and making sure that you know exactly the path you need to take before, like I said, you're saddled with any kind of bills, after death.
How does that, what's the time frame for you guys on the letters? A testamentary.
I mean, it has to go back to court. So we're going to tell you either have to get your probate attorney to refile it or petition the court to extend the letters. 30 days. If once we determine that the letters are expired, then you can just go get new letters reissued.
Okay. Well, so if say they're issued today, someone has a letter, but then they need to do an estate sale. They probably need to sell a car. They don't get to the real estate for 12 months. Is it 12 months or is it?
No, it's more like 4 years. So
okay.
If you probate a will because you're going to liquidate some assets within the estate, but you're going to hold on to the real estate because maybe you're letting niece move in or brother move in, and then you try to sell it years later, after the letters have expired, then we have to go get new ones issued.
Okay. And that takes about 30 days once you identify that?
30 to 60. Let's say on the, maybe the court docket is full, you maybe look at 90 days.
Okay. Especially in Dallas County, probably.
Yeah, Dallas County is busy.
I've gotten to know the judges in Tarrant County, and just by sponsoring the lunches, it's really nice to know.
I know they're good old boys down in Tarrant County. Dallas is a whole different ballgame.
Yeah. Yeah. So we're at 30 minutes now. Can you go into just how you got into this business and your background, your kind of resume, I guess?
I sure can. So I was 18, 19 years old. I was in college. I needed a job because my parents didn't want to pay all my bills. And I applied for a real estate. I applied to be an administrative assistant to a real estate broker in South Lake. And he hired me. And on my first day, he owned a title company too. At the time, I didn't even know what a title company was. He had a mortgage company, a real estate brokerage, and a title company all in one in South Lake. And I was 18, 19 years old. I didn't know what a title company was or why one existed. And this should have been my first sign. But on the first day I started, his title company staff walked out. So he told me, go down there and figure out my title company. Okay. So I went down there. I'm trying to figure out, at the time, I didn't know what a warranty deed was, what a deed of trust was. I didn't even really know what happened when you bought a house. I was just trying to, be an administrative assistant, secretary to the broker. Well, I mean, you see where that story ended. I fell in love with it. Title's a love-hate industry. You don't do it because you kind of like it or you need to pay your bills. You either love what you do or you don't in this industry. So I loved it. And let's see, it took me, because I had to teach myself a lot in the first place. I believe I had my license, my escrow license, that is, which is issued by the state of Texas to allow you to manage escrow money in a file. Title companies manage all the money, all the loan proceeds and the sales price. Allows me to sit at a closing and facilitate the signing of the documents and run everything through escrow. My escrow license allows me to do that. It's managed and governed by the Texas Department of Insurance.
Mm.
We have ethical standards and a code of conduct that we have to adhere to. I had that within 3 years. So I had my escrow license by the time I was 22. And I just began working, developing relationships. I was very loyal. So once I was at a title company, I never wanted to leave because you develop relationships and you don't want to leave. And I was with a particular title company for a long time, a fee attorney office. I would say I was there 11 years, maybe 12, when my business partner now and I decided we wanted to open our own. So we opened our own in 2016 and took our relationships. We wanted to be able to be moms, be wives, and have a career. And we wanted to create a title company that was focused on family first. And that's what we've done. And we're really proud of it. We had no idea it was going to take us to where we are now, but we have multiple locations. We have an amazing team that works with us that we've handpicked.
Oh, Hannah.
Go Hannah. We all love Hannah. Hannah came to me from a cleaning salon. She started with me as my receptionist. And as Dave is saying, she is incredible. She, much like me, had drive and initiative at a young age, and she has a really big career ahead of her. So, I mean, I love what I do. I love the people we get to serve. Hannah says it best, particularly in situations that we're talking about right now, when there has been a hardship or something happened in someone's life. If we can help make that transition a little easier and a little less stressful and a little less expensive, that really is, we're very proud of that. And we really do enjoy helping people and being creative and finding solutions that other people won't typically try to assist or help do. It really, because we're family first, we understand that these chapters can be difficult. And we can be a part of your story and helping you close that chapter and move on. That truly is what we love to do.
That's cool. Yeah. And whenever you could avoid probate and then you go and get somebody that knows the law back and forward, I mean, it's someone
That's the beauty of it is we have our attorney, Ian Greist. He works very closely. He's a text message or a phone call away from me. If I need him to give his attorney stamp of approval or maybe draft some language for me, it's at my fingertips. Where not a lot of title companies are going to have that to offer.
Or even an attorney. If you're just focused on probate, nothing bad about attorneys in probate. I love them to death. But if they want that fee they have to file that probate regardless, and that exposure of their legal knowledge and their career, for them, they want to go through that process. For you, if we could avoid it, we can.
We can, and everybody moves on, and it's not quite as painful or as drawn out. Absolutely.
Hey, I just wanted to say the call dropped, the audio version dropped for the end of the call, but what we did is just in the call at that point, I asked her to tell us where she was, where she worked. So I just want to pull up, it's Grice Title and Law in Colleyville, Texas, that April Thrasher works for. So if you want to get a hold of her, this is their website. You can get a hold of her, meet the team here. We Mainly, we work with Hannah. This is April. She runs it. This is her team right in Colleyville, Texas. They just moved to a gorgeous office. Let's see here. Contact them. You complete this form. But their principal office right here on 6201 Colleyville Boulevard. Phone number is 817-415-2800. So reach out to April. She's wonderful to work with. And we'll have her on more of this podcast. Thank you. And if you need any assistance, make cash offers, guaranteed cash offers that close on properties. We have the resources and the funds to buy a property if that's the direction that your family wants to move into. If you want to avoid probate or you're going through probate, and if you need these forms filled out, completed, or for us to meet with family members, either in the state of Texas or do it virtually online or negotiate a deal for you. The last thing, as a real estate broker, if we can't buy it, the number's too low, and we just can't meet to a certain number, we can help you market the property as a real estate agent, and our fees are negotiable. We want to work with you. We want to do all the paperwork. We want to get the closing costs paid. We want to make sure you benefit from the equity that is in the property. And if there's any liens on the property, we'll negotiate those, like solar panel liens, any city mowing liens, contractors attached. We've had liens with contractors that did work on property that we discovered. So anything we need to do, a title search will locate and negotiate anything for you as a real estate professional or as a buyer. Thank you. Have a good day. Bye-bye.